Good morning, Kevin. Can you hear me okay?
Yes, I can hear you.
All right, can I see you? Good morning, Margie. Can you hear me okay? Are you able to hear me, Margie? Hello, can you hear me? Okay, perfect. Just checking in, make sure everything was working. Hi, Michelle. Can you hear me okay? Yes, okay.
Did you hear me? I'm sorry, I wasn't, I was muted.
Yeah, I can hear you now.
Okay, I'm gonna mute again though, I guess. Yeah.
Perfect, sounds good.
Okay.
All right. Can you hear me okay? Yeah, can you hear me?
I can.
Okay, good morning. Okay, so there's just one last person. Hari, are you able to hear me okay? And are you able to start your video just so we can check in with you?
Yes, I can hear you. I'm here.
Okay, excellent. Okay, if everyone's ready, we are live on YouTube and we're recording. I'm ready to go.
Great, thank you. Good morning. My name is Emily Supinger and I am the chair of the Zoning Board of Appeals. I would like to take a minute to remind everyone of the rules governing this proceeding. This proceeding is at all times governed by the rules of procedure adopted by the board on October 17th, 2011, as amended on February 20th, 2014, May 18th, 2017, and January 17th, 2019. A copy of the rules of procedure is available for review online. This is a quasi-judicial hearing. As such, the board reserves the right to deliberate in private. The Ohio Rules of Evidence do not apply to this hearing. However, professional rules of conduct do apply, and candor to the tribunal is required. The board members are citizen volunteers and are not paid for their service. They are treated as public officials under Ohio law. At any attempt to influence them, including but not limited to bribery, intimidation, retaliation, which may include contacting their employer in an attempt to exert influence, is punishable as a crime. All should be aware that this meeting is being recorded. Therefore, please speak clearly into the microphone and state your name and address for the record. In the event of any technical difficulties with the video conferencing technology, I may continue or postpone this hearing at my discretion. All participants providing testimony must have both camera and audio features turned on in order to participate. With that said, let's proceed to the first case. We have one item on the agenda today, case number 4062-2021, pertaining to 1416 through 1430 Central Parkway. I want to remind everyone that this is a record hearing. The board members will not be taking any new testimony today. I would also remind the parties that the board members have received a copy of the transcript of the hearings below and have reviewed those materials. So we will go ahead and get started. Ms. Ryan, are you ready to proceed?
Yes, Madam Chairman, we are. Just to be clear, do we have an opportunity for our prior witnesses to make any statements or response to the training?
Anyone who spoke below can provide any additional explanation, but we're not taking testimony, so to speak. we'd prefer to hear argument. Also, it is a lengthy transcript. So if you're going to refer to materials in the what we received, if you could give us a second and provide the page number so all the board members can follow along, that would be great.
Okay, thank you. Good morning, everyone. My name is Kathy Ryan of Wood Lamping, representing the appellant and original applicant to the application Moment Development, Luminat. I have with me today everybody who was available at the hearing before the historic board, available to answer questions, including those individuals, Josh Polchinski and Kevin Schubert, who were the individuals who wrote the reports regarding the construction and stabilization estimates. We have Owen Patel, who is a representative of Moment Development, Jeremiah Hahn and Matt Erdman of Luminat Associates, Brahma Ramaneni, who owns the property. So I wanted to start today by providing kind of an overview of what is before the board concerning this matter. This is confined to the demolition. The historic board decided to deny the demolition without any basis in the record based on any reliable or credible evidence. We agree with Mr. Suter's letter that yes, as applicant, we do have the burden of proof by preponderance of the evidence that we meet the standards in 1435-092. We have met those standards by a preponderance of the evidence. As we've provided extensive documentation and testimony before the historic board. We've got the Moment Development letter, pages 88 to 92, which provides a preliminary analysis by Mr. Patel of the application's adherence to the standards. We've additionally provided a pro forma analysis, economic analysis of a number of proposed uses on the site, pages 93 to 111. Mr. Ramaneni included a letter indicating his history with the site as owner on page 112. We have property comps that form part of the foundation of the analysis on pages 113 to 135. And all of this is based upon Advantage Group Engineering's evaluation of the property and what it would take for basic stabilization, and HGC's estimations of what that stabilization would cost. And those are found on pages 136 to 150 and pages 151 to 153. In addition to that, we have a staff report that offers extensive analysis of what we've provided and a recommendation of approval, specifically on pages 12 to 17 of the record. And included with this is support from the Cincinnati Department of Economic Development, pages 222 to 229, where they have provided their own independent pro forma of the same site and the same parameters and same variety of uses, where it supports the findings that are submitted by the applicant. And in addition to that, on page 30, we've got verification also from the City Economic Development Department that the analysis when considering the potential federal tax credits, as we've also asserted, does not adjust it whatsoever to create any sort of economic feasibility on this site. All of this information provides a sound foundation for what we believe is adherence to the standards in section 1435-092. This includes the economic viable. Is there any economically viable use of the property, or is the owner deprived without approval of certificate of appropriateness? We've asserted, and the City Economic Development Department confirmed on page 223 of the record, this analysis is based on stabilization for any reuse of the building. So on a foundational level, this use will require, or any use would require basic stabilization of the building, some preliminary costs to get that going, and that would be required no matter what use is entertained at this site. The historic board makes an observation that, which forms the basis of their denial, where they make a number of findings, including that this space has been occupied in part by the owner for office, about 2,500 square foot, a small fraction of that site. There is nothing that indicates that a site, any building that is used in part, is per se economically viable. That's just simply not a standard. That's not a sound analysis of economic viability. As Mr. Aminetti testified, they have always operated at a loss at this site. They have owned the building since 1997. The special designation on this site did not occur until 2014. Mr. Aminetti testified that this site, they attempted to maintain basic maintenance levels, but did not find there to be any economically viable use in making the entire building usable. They were able to secure tenants years ago, as it's stated in the record, and over time, the marketability of this building for tenants as it exists became impossible. And another aspect to which Mr. Aminetti testified is that they have no orders against.
Kathy, we can't. Kathy, we lost you for a second. We lost the sound. Could you repeat your last sentence?
Can you hear me?
Yes.
Okay. Mr. Aminetti also testified to the fact that there have been no code violations at this site, and the historic board observes and oddly enough uses this as a basis for denial, points out that there have been no code violations or complaints from neighboring property owners. Again, economic viability, the stability of the site, the condition of it, and how it may be used in the future does not require outsiders to come in and have complaints. And in fact, when it comes to the standard regarding whether this was exacerbated, I would surmise that had we shown that Mr. Aminetti bought the building in 1997 and there were any orders, that those could simply be used to prove supposedly that he maybe exacerbated the issues on the site. But that's not the case. He has maintained the building as it was found since 1997. He testified in the record to the fact that this site, long before he ever owned it, was covered with stucco. And the structural report supports this. Mr. Erdman's testimony supports this as well, that there has been significant degradation and deterioration of the structural soundness of the building because of that stucco addition that happened long before the applicant or owner ever had possession of it. That's the sort of thing that would be something that proceeds over time on an exponential level to cause deterioration and have costs associated with it, where even if you maintain a building and do not exacerbate the deterioration by anything you particularly did, there's still a possibility, and we attempt to prove that the costs to maintain this building at a basic level, as Mr. Aminetti has since 1997, at some point it outpaces any economic possibility of doing that practically. The historic board also states it cannot be ignored that other development scenarios for the property may have the potential to reduce the hardship. Again, this completely ignores in the record the analysis provided that we have offered several pro forma options. The city has those as well, and all of these are based on stabilization that would be required for any use of the site. The second standard, will the reasonable investment-backed expectations of the property owner be maintained without the approval? Again, we've testified to the fact that this site had certain structural conditions that were set up to fail decades before the current owner possessed the building. This site was not recognized in the way it is now in 1997. It took many years after until that became the case. And all of this is supported again by the expert reports provided in the record. And whether the economic hardship was created or exacerbated by the property owner. I've already touched on that, but a number of additional standards are provided in the code for consideration by the board. The property's current level of economic return. We've provided that this property has been operating at a loss by someone who owns the building and carries absolutely no additional costs to the building other than basic maintenance, property taxes, insurance, and those sorts of things, as Mr. Amanini included in his letter on page 112 and testified to. The second standard, BB, any listing of property for sale, rent, price, ask, and offers received, if any, within the previous 2 years. Again, and I'll touch on the reference to this in the banker's choice case, but Mr. Amanini also testified to the fact and answered the question by Chairman Voss of the Historic Board that he did have some reputable organizations, 3CDC Model Group, evaluate this site, and nothing happened. And here before you have a third possibility of Moment Development evaluating the site extensively, as you can see in the record, and coming to a conclusion that this site as an overall development is a site where 2 out of 3 of the buildings are worth saving, can be saved, can be used economically in an overall development that includes a hotel and other things that would be slated for the site. The third standard factor to be considered, the feasibility of alternative uses for the site that could earn a reasonable economic return. Again, our pro forma includes 4 options, as does the city's, I believe, includes 4 to 5. And all of that, once again, based on stabilization required for any reuse of the building. Any evidence of self-created hardship through deliberate neglect. I've already touched on this, but again, Mr. Amanini bought this building at a time when it had conditions on the site, adjustments and modifications that were, even if not evident at the time, would eventually aid in its degradation over time. He himself has had no violations or complaints from neighbors, no violations from the city. He's maintained it as he could with just basic maintenance to try to keep it afloat for as long as they could. Knowledge of landmark designation or potential designation of time of acquisition. Again, that was a 2014 designation. He purchased the building in 1997. And then economic incentives and or funding available to the applicant for federal, state, or city, or private. Again, we've worked with Luminat to Luminat has extensive experience. This is what they do. They their ability to analyze these sorts of incentives is exceptional. They've done that. They've also had independent verification from the city that those tax incentives won't help get this to a point where it would be feasible. So we believe by a preponderance of the evidence, what we've provided in the record in and of itself shows that this building should be granted a certificate of appropriateness for demolition. Mr. Suter states in his letter that he tries to say that I conflate the issue, that I somehow suggest that they have a duty to disprove what we're asserting, but that's not what we're trying to do. The point here is that we have proven by a preponderance of the evidence that we meet the standards in the code required to allow them in demolition of the building. But of course, that's not the standard. You have to look at the entire record. The record here includes it includes a few documents and testimony from a number of individuals in opposition to the demolition. So to fully evaluate whether the historic board's decision was reasonable, you do have to look at the entire record, obviously. And that's what we've done. And we've presented in our letter a summation of all of that testimony and evidence to show to you that this, in fact, was an unreasonable decision, unsupported by the record, by the historic board. And just kind of briefly, there were about 8 individuals who testified in opposition to the project. 3 of those did not testify whatsoever about demolition. One of them just expressed in writing and in person her general opposition to the project. That left a few individuals who touched on the demolition. These are not experts in any of the areas that we've presented evidence, or if they are, they have not indicated that in the record. It's just kind of general opposition. I've quoted it in our letter, you know, statements about, well, this just strains logic. The building is irreplaceable. Mr. Mueller of the Cincinnati Preservation Association said, well, you just need to have a closer look at the building. The overall evidence presented by anybody opposing what we've asserted, it was just kind of general, bare assertions, not based on any sort of reliable or probative evidence. In addition to that, we've not had any assertions made by the city staff, by Mr. Suter, by any of the people presenting any testimony that calls into question anything that forms the basis, the foundation of our analysis, or of the city's for that matter. And again, that would include the property comps that we've provided, Advantage Group's analysis of the structural condition of the property, HGC's construction estimates on the cost of that. You know, every one of these things, the analysis of the tax credits, there has been no reliable and probative evidence attacking or trying to undermine any of that. And we believe that's because it is all reliable and something that should be held and given greater weight than it was given before the historic board. And then finally, I did reference the case made previously that is a similar case and analyzing these same standards, the Banker's Choice case. Mr. Suter provides in his letter that he says, well, this building was kind of falling down. And yes, it was falling down more so than this building. It was condemned and this building has some level of occupancy. But again, that's not the standard for 143509-2. As Mr. Amaneni had testified, they've been able to partially occupy the building, but that's become increasingly difficult. And their ability to have any sort of economic viability at this site is something that we believe we've proven in the record. We believe that the historic board's analysis completely ignores the weight and strength and credibility that should be provided to all of the experts who have submitted documentation in support of demolition. Again, I'll go one more time and then I'll be finished over what we believe are the basis. They say again, applicant's justification for demolishing the building is based on the premise that the building is in such disrepair cannot be rehabilitated or sold for the purpose of rehabilitation without suffering a financial loss. You'll see in that case, whether or not they can sell it isn't something that is necessarily the requirement here. But nonetheless, Mr. Amaneni had indicated that they've entertained selling the property or evaluating development possibilities on the site. Again, and the board states on page 5 of its decision, any outstanding building code violations or complaints from neighboring property owners of blight or disrepair haven't occurred. That does not speak to the standards of 1435-092. The third point they make is that the building has been occupied. Again, this does not speak to the economic viability and the standards of 1435-092, especially when you consider the testimony provided by Mr. Amaneni, by Mr. Erdman, and the documentation by the structural engineer and the construction company regarding stabilization. And again, the scenarios, just completely ignoring the record where we have provided that this site has always operated at a loss. We've evaluated so many scenarios on the site, and any scenario would require stabilization of the site. And it is the stabilization that we are saying makes this not economical. We believe that the decision by the historic board was unreasonable. We believe that it failed to consider properly the weight and credibility of what the individuals and the reports that we've provided. We believe that the opposition's evidence and testimony doesn't come close to undermining or outweighing, excuse me, that case that we've made. And as such, we would ask that the zoning board reverse the decision of the Historic Conservation Board denying demolition. Thank you.
Thank you, Ms. Ryan. Do any of the board members have any questions for Ms. Ryan at this point in time? Okay, hearing none. Mr. Studer?
Thank you, Madam Chair. Thank you, members of the board and city staff. My name is Sean Suter. I'm a member of the firm Suter LLC. We're at 455 Delta Avenue, Suite 203, Cincinnati, Ohio 45226. I'm here on behalf of OTR Community Housing, Margie Waller and Danny Klingler, who are all parties in this case. Let's just be clear, I think, for everyone. The applicant wants to demolish this building because it's in the way of the hotel that they want to build, okay? The HCB saw through this. You know, if the hotel hadn't come along, they'd continue to occupy it as they have been for years now and continue to let it deteriorate until some other development came along. That's the reality of the situation. The only failure here was the failure of the applicant to prove with credible evidence, that this pre-Civil War historic canal building should be raised. This isn't the Davis Furniture Building, okay? Let's put that aside. The Davis Furniture Building was determined to be crumbling, dangerous, quote, not in good shape whatsoever, vacant, unsafe, unsanitary and deteriorating. They have major structure and damage issues. In fact, the court went as far as to say to cite that the city had ordered Baker's Choice to undertake certain safety repairs to alleviate a clear and present danger to first responders. That building was unoccupied, it was in shambles, and it was determined through all the evidence and years of back and forth not to be salvageable. It was deemed to be unsafe. The applicant continues to discuss stabilization. This building's in use. It's been in use. What are we stabilizing? If it's so structurally unsound, why are they occupying it? The city hasn't ordered them to vacate the building. Nobody's determined that it's structurally unsound. And if they have, they shouldn't be using it and occupying it. This building is an occupied building. It's been occupied and used as an office continuously under the present ownership. Whether it's fully occupied or partially occupied, doesn't matter, it's occupied. And now it is simply inconvenient for the developer to keep as part of its larger proposed hotel development. The HCB reviewed a mountain of evidence presented, including the self-serving pro formas from the applicant, and they correctly held that it wasn't credible. The city's economic development department, for some reasons, opining on this, but we couldn't ask them because they weren't present at the hearing, which I objected to. None of that's credible because we had no idea what they based their opinions on, and we weren't able to cross-examine them. So this board's job is not to reweigh the evidence as applicant would like you to do. This is not a do-over for the applicant. This board's role is to check and see whether the Historic Conservation Board reviewed the evidence in light of the factors for economic hardship in 1435-09-2B. And there's no indication from the record that the board did not do so. In fact, to the contrary, the Historic Conservation Board considered factors A through F in detail and considered the evidence that the applicant does not have a building that is in blighted or disrepair condition, unlike what was found to be the case for the Davis Furniture Building, that the building is occupied and has continuously been occupied, that the owner purchased the building with full knowledge that it must be maintained as a historic building, could not be demolished, that any alleged hardship is self-created. You know, they didn't perform the maintenance, even if it's difficult maintenance, it doesn't matter. You have to maintain a historic building. You have a responsibility as the owner of a historic building in a historic district and over the Rhine to maintain the building. You don't get a pass just to say what's too hard. So I let it deteriorate. That's not the standard here. So my clients did not have the burden of proof. There seemed to be a shifting or attempt to shift that burden on us to say we didn't make a showing. We didn't have to make a showing. It's the applicant's burden to make a showing that it was appropriate to demolish this building. But my client did present credible evidence and information of the historic significance and the viability of this building that simply outweighed the self-serving, non-credible evidence presented by the applicant. Applicant's justifications and true motives here don't overcome its high burden. Convenience is not a justification. Not being profitable is not a justification. The fact that they're operating a building at a loss is not a justification for demolition. If that's the case, we might as well tear down Over the Rhine. We wouldn't have an Over the Rhine if that was the case. None of those buildings were making a profit. There might be some of them now, but many of them still aren't. So profitability and, we just can't make a buck on this, and it's too hard to repair. It's just not convenient. We want to build a hotel. None of that rises to the level of an economic hardship that says, look, we can't do anything with this property. There's no viable use. It's got to come down. Otherwise, it'd be a taking of our property rights. That's not what we have here. Again, this isn't a do-over. The applicant doesn't get the opportunity to make the case they should have made to the Historic Conservation Board. The board looks for decisions that are illegal or arbitrary or capricious or unsupported by the evidence. This board looks for error. There simply is no error here. The Historic Conservation Board decision is sound and must be upheld. Thank you very much for your time today.
Thank you, Mr. Suter. Do any board members have any questions for Mr. Suter? Cassandra, did any other persons file a notice of appearance to be heard at this hearing?
No, I did not receive any.
Okay. Having none, then we will hear rebuttal from Ms. Ryan.
Thank you. Just very quickly, initially, Mr. Suter states that this is all about key timing with the hotel and everything, and the stabilization. Why are they occupying the building? There is a distinction between occupying the building partially, as they have done for a number of years, in a way that has been operating at a loss that entire time, and making any sort of economically viable improvements to the property that would need to be made to bring it into any other sort of use, to bring in any outside parties in a marketable economic way. Mr. Amanini had testified to that there would be certain improvements. Elevators come to mind. There's certain things with the floor joists and the water intake from the stucco issue. A number of issues in the record that are stated that would need to be changed to make this an economically viable use. That doesn't change the fact that while it's been a difficult building, they've maintained it at a minimal level, occupying only part of it at a loss. Mr. Suter states he lodged an objection to the absence of the economic development representative that had performed the independent analysis of this site. I will say I didn't see any indication in the record. Mr. Suter said, is he here today? He was free to request his presence at the hearing in advance. And even in his absence, he had full opportunity to cross-examine and question Beth Johnson on the staff report that relies on that analysis. Matt Erdman, Om Patel, Josh Tolchinsky, Kevin Schubert, they were all here making the same or similar assertion about the economic viability of this use. And that was not done. So we do not believe that that individual's absence, the city's representative's absence, in any way undermine their opportunity to highlight what they believe are supposed weaknesses in our case. And again, I'll repeat, and you state this in your introduction, that board is not subject to the same evidentiary rules regarding that matter. So some hearsay evidence and letters are allowed in the record. Mr. Suter repeatedly states they didn't perform maintenance. They let it deteriorate. That simply isn't true. He asked that on cross of Mr. Romanelli in the record, and Mr. Romanelli denied that because that's the case. The historic board even says in their decision, there have been no code violations or complaints from neighbors. This building has not been, there's no exacerbation of any sort of deterioration occurring. They have maintained it the best they can for a number of years, and not in a way that would cause it to fall into disrepair by way of neglect. Again, he states that they gave credible evidence of the historic significance of the building. That's simply not the standard here. The standard is historic or not. We are accepting that that's the designation, and because of that designation, we applied to the historic board to prove under the standards that we need an exception to that designation to get the demolition. And then finally, I think there's a little bit of the big bad developer who only cares about money wants to knock down this building. Well, that's simply not the case. He uses the buzzword profit. They talk about profit. That's not the standard. That's not the term that is significant here. It's economic viability. And that is something to which we provided an extensive analysis. And in so doing, we've allowed a building that has been operating at a loss the entire time to have a new opportunity to be part of a larger development where 2 buildings are saved, 2 historic buildings are saved and rehabbed. And this one, because of the myriad issues here, is demolished. That doesn't undermine whatsoever. The fact that this is a part of what would be a larger development is simply not something that undermines the fact that we do meet those standards. And the use of the word profit, I would just object to that. That doesn't, I'm not sure what he means in that sense, because we're here discussing economic viability of the site under the standards in 1435-092. And we believe again that the record shows that the applicant has met its burden by a preponderance of the evidence or by credible evidence that this site specifically is in a unique position where it cannot be sustained in an economically viable way without demolition. And we would ask you to reverse the historic board's determination that this demolition is denied. Thank you.
Thank you, Ms. Ryan. Under the rules of procedure, the parties have an opportunity to present closing statements with the appellee going first and the appellant following. Before we do that, I just want to check with the board members. Are there any questions for either party before we proceed with closing statements?
Madam Chair, I have one quick question of Mr. Suter. I'd like to hear Mr. Suter's response to Ms. Ryan's comment about having the opportunity or lack thereof to cross-examine Beth Johnson, cross-examine the author of the Advantage Group Engineers report, the HGC report, because I've heard the economic analysis called self-serving. I've heard all these reports called being classified as lacking credibility, but I don't think I've heard why it's self-serving and why they lack credibility.
Thank you, Mr. Benny. Yes, I had the opportunity to cross-examine all of the people that Kathy mentioned, I believe. I have to go back and look at the record of who exactly cross-examined, I don't recall. And we did test their assumptions underlying their reports and pro formas. In fact, I remember having extensive discussion with Mr. Aidman, is it, the architect? So that should be on the record. I did not have an opportunity to cross-examine the author of the report from the Economic Development Department. That was my objection. Beth Johnson did not author that report. That report was authored by somebody in the Economic Development Department. It may have been part of her report, but Beth Johnson wouldn't have been able to testify to the author's analysis of that report. So I didn't have an opportunity. There's no subpoena power at the HCB. There was no way for me to compel any witness to testify. They didn't show up. I objected, asked for them to show up, and they noted the objection. And so that's where we are.
So understood and saw those parts of the record where you were able to cross-examine. But again, I've heard you classify some of the evidence that was presented below as lacking credibility and self-serving, but I haven't heard why those classifications are being made.
I think that's set forth in the decision of the historic board. And I could point you to some of that stuff here. Let's see. Well, I think the reason you don't have it is because there wasn't sufficient evidence to prove it. And so there was nothing credible or that convinced the historic board that there was an economic hardship because they used the building. That's one reason. Because they never tested the market. That's another reason. They never put this property up for sale. They had it evaluated. We believe that was self-serving to make this case, but they didn't put it broadly for sale, market it for sale. What other things in here to look? The maintenance issues were brought on by themselves. So that, the fact that the property was not making a profit was just one factor. There were other factors too about whether they self-created these issues and whether they knew that it was a historic building when they bought it, and whether they contributed to the demolition essentially by neglect, if you will. And so that should all be on the record. But there wasn't convincing that the HCB wasn't convinced with what they saw. And it's not for this board to reweigh the evidence, eventually, ultimately to look at the HCB's decision and say, did they err?
Any other board questions before we move on to closing? Okay, thank you. Mr. Suter, do you have a closing statement?
I didn't really prepare one, but I would just say quickly that, again, the burden is on the applicant. They didn't meet their burden before the Historic Conservation Board. Again, it's not really for this board to second guess or reweigh the evidence or to hold a de novo hearing on the evidence. You really have to look at everything that was presented, the evidence in the record, and say, did the Historic Conservation Board err? Did it act arbitrarily, capriciously, illegally? Is this so far flung from, is this so outside of reasonableness, based on the evidence that was presented to them? And, if you look at it, there's no error. And so there's nothing for this board to do. The decision should stand. Thank you.
Thank you, Mr. Suter. And Ms. Ryan. Anything further?
Thank you. Thank you. I won't belabor everything I've already gone over. I would just say again, we believe that this case that we've made is a strong case based on credible evidence and extensive analysis, extensive history on the site, why it is the way it is today. And we believe that the historic board's decision shows that they did not adequately or appropriately analyze the evidence or consider the evidence as is required under 2506 and under your zoning code. We believe that the only acceptable outcome here, if you were to properly weigh and evaluate the sum of all of the record, is that this site should be granted a certificate of appropriateness for demolition. Thank you.
Thank you. Thank you, Mr. Suter and Ms. Ryan, for your presentations and arguments. Is there a motion by the board to adjourn into private deliberation?
So moved.
Is there a second?
Second.
Mr. Moran?
Aye.
Ms. Powell?
Aye.
Mr. Benny?
Yes.
Mr. Heenan? I couldn't hear you, Scott.
Emily Scott is with the law department.
I apologize.
I apologize for not introducing him earlier.
Okay, my apologies.
He will not be voting.
Sorry about that. All right, and I vote aye as well. So we will now adjourn into private deliberation.